Hello, and welcome back to Main Justice. It is Tuesday morning, June 23rd. I'm Andrew Weissman, and I'm here with a wonderful, terrific, fantastic Mary McCord.
You're just trying to make me feel better because you know I'm feeling run down and overwhelmed and exhausted. So now I'm energized and ready to go. Okay.
Um, it's because everyone should know Mary McCord has like 7 day jobs. One of the things that we're going to talk about today is something that you are actively involved in, and it's fascinating and interesting. And that's not just as a teaser. Mary, what are the 473 things that we're going to cover on today's show?
Well, first, let me say what we won't cover because it is Tuesday morning, but we are recording before the Supreme Court issues opinions. We know today is an opinion day. We know that Thursday is also an opinion day. It could be that on one of these 2 days, the Supreme Court will issue one of the long-awaited decisions, such as a decision in the birthright citizenship case, a decision in the attempted firing of Federal Reserve Board member Lisa Cook, and other really important decisions. We obviously are not going to talk about them because they haven't happened yet, but next Tuesday, we shall see.
Yeah.
So our first bucket of things will be sort of in the Trump administration's consistent effort to really divest courts from jurisdiction to rule on things that it wants to do. So the avoidance. We would like to avoid judicial review because we might lose there. So we are going to talk about things like not filing the declarations that the court ordered about ending the slush fund, the so-called anti-weaponization fund. We're going to talk about a very interesting case brought under the Clean Air Act by citizens because Congress provided citizens a cause of action when the government is not moving to enforce the Clean Air Act. And the government is saying, nope, if we don't want to enforce it, you can't rule on it, court. Another thing that the government would like to avoid judicial review of is whether government officials were in contempt of court more than a year ago when Judge Boasberg in the D.C. District Court ordered planes not to remove alleged members of Tren de Aragua from the country and turn them over to El Salvador. And that is a case that the D.C. Circuit has agreed to have en banc argument in. Then we will move into DOJ on the offense, the Minnesota indictment of 15 protesters last week on a conspiracy charge to really hinder and impede federal ICE officials from doing their jobs. And related in Minnesota, the chief judge of the district court there has just issued a really scathing opinion quashing subpoenas against the governor and the mayor of Minneapolis and other officials. 6 people. Folks might remember the big fishing expedition with subpoenas that were issued during the Operation Metro Surge, the ICE surge in Minnesota. And these were for some sort of vast investigation that DOJ was allegedly doing. And this judge has said, no, this is an improper purpose. This is done in such obvious retaliation for the exercise of First Amendment rights and the exercise of the right of the state and the cities to not voluntarily cooperate with immigration enforcement.
And those choice words, Mary, I would say we have upcoming confirmation hearing for Todd Blanche. And there's some fascinating and interesting things that this judge has said about Todd Blanche. To be fair, not just Todd Blanche. So more on that later. But Mary, who are we going to hear from today on what subject?
Yes, we will hear from our friend, Tess Bridgman. She is the co-editor-in-chief of Just Security. She was in the legal counsel to the National Security Council's office. She's been a State Department lawyer, and she is going to talk about the so-called Memorandum of Understanding between the United States and Iran that has made so much press, as it should, really to try to end this war, reopen the Straits of Hormuz, but also allegedly to deal with the issue that President Trump claims prompted the war, which was ending the potential development of a nuclear weapon by Iran. And the reason Tess is such an expert in this is she was there in the White House working in the counsel's office at the time that the former agreement under President Obama, the JCPOA, was entered into. An agreement that, of course, Donald Trump has said was awful and horrible and pulled out of when he became president. So she will walk us through some of that. And I think it'll be so helpful because it is complicated. We should be devoting an entire episode of it. This is going to be really just a primer, but I think it will be useful. I didn't even flag Las Cruces, but we'll just get to Las Cruces. That's a
And that's the case that, Mary, you're a little bleary eyed because you've been burning the midnight oil with your team on that case.
and others that we're not even going to talk about, but okay.
Yeah, exactly. So, Mary, let's turn for a moment to the so called slush fund case. Now, there are two cases. There's one in Florida. We're not talking about that today. This is the one that is in the Eastern District of Virginia, where Judge Brinkema, a very experienced, very well respected judge, has a case where the government said, the plaintiff's case should be dismissed because it's now moot, because they're complaining about how the slush fund funds would be used. But the government said that's now moot because we are not going forward with that. And the judge had said, before I dismiss a federal case, now the government is the one that is asking for relief. The government is saying, get rid of the case suing us because we're actually not going forward with the thing that they say is wrong, so that it's moot. There's no
Yes.
issue here. Look, this under normal circumstances is a pretty good argument, right? The judge says, but here's the problem. I heard the acting attorney general, Todd Blanche, he testified that they're not going forward with it. And there were statements made in other court filings that they're not going forward with it. So normally that would be sufficient. But here you have the president of the United States, who is certainly not shy about ordering his Department of Justice to do whatever he wants it to do, has said, no, I like it. And so there's a real issue about whether underlings saying that they think it's not going to go forward is really something that should carry the day. And you can understand what the judge is saying, which is, I need you by a date certain to put
Last
in
Friday.
writing, and it needs to come from essentially the people who are the top agency officials. She doesn't say the president has to file it, but it's like Todd Blanche and two other people who are cabinet level officials need to put in writing, if you want me to dismiss the case, right? That's sort of the key.
And declarations, to be clear, when you file them in court, they're basically under oath, right? You're swearing to something.
And so that was what the deadline was. And for understandable reasons, because the judge is like, you want the relief. So I need to be confident before I'm going to take someone's rights away to sue that it's really true.
Yeah. She said either file these declarations by Friday, the 19th, or respond substantively to the lawsuit by the date that that's due.
Exactly. You have a choice.
Yeah,
right?
that's right.
What is it, Dr. Seuss? If I said what I meant and I meant what I said, it's like, so if you meant it, say it in a filing. And so, Mary, the due date came. And what did they say about the president's comments? Because I was looking very closely at that.
Yeah. Well, nothing. Zero zilch.
Exactly.
Nada. So this is a 5-page filing by the DOJ. And here's what's interesting to me. They could have just done these declarations, right? They could have done a declaration by Acting Attorney General Todd Blanche saying the anti-weaponization fund that was part of the settlement of President Trump's lawsuit against the IRS will not be going forward. We are withdrawing that portion of the settlement agreement, right? We are voiding it, whatever. They could have just done that, right? I mean, he has said to Congress, we're not going to go forward. They could have just done that, but they don't. And I think it's because it is part of, again, this unitary executive theory on steroids, which is what the environmental case is really about too, and what so many of the things that this Department of Justice has been filing in court seem to be about, which is that this essentially is intruding on the president's authority to require declarations. We've already said before Congress, some of us have already said here in court to you, Your Honor, that the anti-weaponization fund is not going forward. That should be good enough. And it says there is no basis for the court to compel testimony from the Associate Attorney General and 2 cabinet members. The point of Article 3 limitations on judicial review. Now, remember, Article 3 of the Constitution is the establishment of the judicial branch, an equal branch of government. But they say the point of Article 3 limitations on judicial review is to prevent such overreach. Indeed, the duties of high-ranking executive officers should not be interrupted by judicial demands for information that could be obtained elsewhere. And of course, this all harkens back to this notion of the president has complete and total authority over the executive branch, over prosecution decisions, over settlement decisions, and basically get out of the way, court. To me, this is just like get out of the way.
This is just, it's a misapplication because this is the government asking for a case to be
Yes.
dismissed because of something that it says is moot. And so the judge is entitled to have a clear record. Now, to be fair, if this administration had not, according to Just Security, which has been doing this amazing tracker of judges' responses, but if there had not been this enormous track record, now proven and documented by Just Security, of judges talking about the disobeyance of court filings over and over again, such that the presumption of regularity should not apply. If there wasn't that, if there wasn't the president saying something different than Todd Blanche said while he was in Congress, then I could understand the government coming in and saying, look, as a matter of discretion, Judge, we know you have the discretion to do this, but we think that you're abusing it. It should be enough that we have said this over and over again. On the other hand, you and I know that if we were in the Department of Justice, we'd just make the filing. This
Yes,
falls
just
also
do it.
into like, could you just be a grown up?
Yeah, don't fight about it.
Exactly. This is like sometimes it's like choose your battles. So it'll be interesting to see what the judge is going to do because the judge issued an order and the order has not been complied with.
Well, and what this triggers now is that the government must respond substantively to the lawsuit by July 17th. So really, I think we'll see, does the government do that? Or does the government
Right.
on July 17th come back again and say, you need to dismiss the case? Now,
Right.
in fairness to the government, I can't believe I'm saying that right now, there is a third case. Another case was brought challenging this fund in the DC District Court. And Judge Leon there did say, when the government said this is moot, Todd Blanche has told Congress we're not going to go forward. He said, okay, I'm going to take your word for it. So, of course, the government goes before Judge Brinkema in the Eastern District of Virginia and says, look, Judge Leon took our word for it. You should too. But for all the reasons you just indicated, Andrew, she's not willing to do that because she feels like there's just been too many times when the Department of Justice is saying one thing in court, the president is saying other things, and then there's no certainty about what's going to go forward.
And to be fair, this is not about her having some bugaboo about this.
Yes,
She is being asked
to dismiss a
To-
case. Mhm.
affect the rights of a plaintiff,
That's right.
right? And so she is saying, before I do that, before I take away their rights, I need to be sure, and you, government, have the obligation that I am sure because you are asking for extraordinary relief, which is that a lawsuit be dismissed. So we'll see what happens. This is a to be continued, but this is maybe a good segue to the environmental case, which is a case where it's a violation of the Clean Air Act, but it would easily apply to clean water, to all sorts of different environmental statutes where the government has gone into court in connection with a civil dispute where there are two private parties who are suing, and the government has gone in and said, we want to intervene as a matter of right, and we want this case to be dismissed. Now, Mary, what's the underlying case about? Like, what's this dispute and how does the law work? Like, why does the private plaintiff have the ability to go into court to sue?
Right. So this is a case brought by the NAACP that is suing XAI. This is one of Elon Musk's companies because it built dozens of methane gas burning turbines to power its Colossus 2 data center in South Haven, Mississippi. And people are probably well aware of the explosion of data centers around the country that have started to become quite controversial. But this isn't just a data center that is controversial because it's big and ugly and it blocks people's view. This is one that is being powered by methane gas. And this is, according to the complaint, exposing nearby predominantly Black communities to air pollutants and emissions without XAI ever complying with the Clean Air Act. It requires permits for this type of thing. It requires pollution controls, and none of that happened.
Allegedly.
Allegedly. That's right.
Just to be clear, I want to make sure people understand. It may be that the NAACP can prove its case, and it may be that it can't prove its case, but it has brought a case. The court would normally go through various motions, potentially discovery, and then ultimately there would be a resolution about whether the plaintiff here, the NAACP, is correct. But Mary, How is it the NAACP is allowed to sue? What's their claim based on?
Yeah. So in the Clean Air Act, like in lots of other environmental and non environmental laws passed by Congress, Congress provided explicitly in the statute the ability for citizens to bring lawsuits if neither the US government or the state is actually seeking to enforce the Clean Air Act or the other act that is at issue. And part of this was to be able to supplement the power of enforcement by the federal government. The states, which might not get around to enforcing everything, and Congress recognizes the value, and we've seen this repeatedly throughout history since this act was enacted, of citizens to be able to bring that suit saying, we're injured by this violation of, in this case, the Clean Air Act. And Congress said you can bring that suit.
So this is a statutory, the Congress is by statute
That's right.
said private parties can bring this suit. So this is a statutory claim that Congress has specifically provided, saying that it's not just the government that can sue an entity that's violating the Clean Water Act or Clean Air Act, but if the government isn't responding, isn't doing anything, the plaintiffs here, civil plaintiffs who are private parties, can enforce the statute. Whether they can win is a separate matter, but the Congress has actually given them that power when the state is not. By the way, the federal or locals are not acting.
And the statute has a carve out that the citizens can't bring that suit if the state or the federal government is diligently bringing a lawsuit to enforce this or diligently working to enforce this.
Diligently is the key. You and I know, have honed in on that because that's the weakness in the government's argument here.
That's right.
Because the statute says that the civil suit is a backup, essentially. And they say when the federal government or the state or locals are not enforcing the statute, that you, as civil private party, can go forward, except if the government steps in or is going forward, whether federal or state or locals are going forward and are diligently pursuing it.
That's right.
Then you don't need this backup. And so you're sort of this secondary level, but you have to be diligently going forward. Well, the government comes in and says, well, we have a right to intervene under the statute, which they do, absolutely. And they just sort of ignore really the idea that they have to diligently pursue it. They say, we have come in and we think that the right to intervene also includes the right to dismiss, and you should dismiss the case. To get this, Mary, at the last page, I was sort of jaw drop, and it needs to be dismissed with prejudice,
That's
meaning
right.
against the NAACP, and it can never bring it again, no matter what, because the government is the only one with the authority to decide whether to enforce or not to enforce this statute.
And we've decided not to.
Exactly. That means, though, that they have to say that the part of the law that Congress passed that said that there can be a private right of action that can go forward unless the government is diligently pursuing, they have to really take the position that that piece is unconstitutional. That Congress, while they can create these rights and this statute, they do not have the ability to do this constitutionally. That, by the way, there is no Supreme Court case that has said that. As a matter of fact, you and I have been texting over the weekend that there's language in at least one prior case that suggests that that isn't the law.
Yeah.
But to me, they really have to be saying this congressional scheme in terms of how it's been put together is unconstitutional.
Well, they are. But they get there after a couple astounding things. I mean, basically, you're going to the court, like you said, and saying, dismiss this entire thing because we, the United States government, have decided, one, and this is the astonishing thing that snuck in there that I just want to make sure people are aware of. We need, as a matter of national security, these powerful data centers to operate and support the Grok AI that is used by the Department of, and I'm going to put this in quotes, the Department of War. And then they admit something that I think is pretty astonishing, which is that during Operation Epic Fury, that is the war against Iran, Grok enabled U.S. forces to deploy over 2,000 munitions to 2,000 distinct targets within 96 hours. Now, do people remember what one of the very first targets in that war was?
Can I raise my hand and answer that?
Yes.
And were the death of school children?
That's it. A girls' school. Now, they don't directly say that Grok AI directed an attack on that girls' school, but 2,000 munitions to 2,000 distinct targets within 96 hours. And that's why we need these data centers.
So can I just give a shout out, by the way, to Asha Rangappa, who early on, when she saw this,
Yes.
flagged this issue as wait a second, this could mean that we were using AI, and was that AI usage responsible for the deaths of these children? And people will remember this is the case where the government was saying, no, 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 we didn't do it, essentially. And by the way, Mary, on this issue of they wanted to say there's a national security issue, there is already a body of law for the government to come in and say there are national security implications here. We would like to weigh in on X, Y, and Z.
They can litigate that, right?
Exactly. This is why we think the case shouldn't go forward. But that's not the government's position here. They throw it in to say it is dead on arrival, and we are telling you why we care about this. And you have no discretion, Judge. And my point about this is, they don't really address what would happen. Are they saying that if the state couldn't do this either, like state and locals, they don't address that? This is a right that has been created by Congress for particular parties. So the government's right to enforce comes from Congress.
And that's why this has implications beyond this particular case, right? Because Congress has written these citizen suit provisions into multiple different laws. And the government's position is if the U.S. can just control all of this, and as they say, it would violate Article 2 of the Constitution and the vesting clause that gives all executive enforcement power to the president, it would violate that for the court to allow this to go forward. So more to come on this, super important and terrifying.
Mary, don't you agree that the way this is written, including the language exclusive and preclusive,
yes,
that this is one which is they are aiming to the Supreme Court?
100%.
We will keep our eye on this because this is going to be a big story going forward. Very quick point before we take a break. As you mentioned, in the Boasberg contempt case, that's one where the DC Circuit 2-1 had said that Judge Boasberg cannot go forward. There was a very vociferous dissent that basically was saying the gist of it, in addition to the substance, was that this should go en banc, meaning that the full court should hear it. And that is what has happened. The full court has said, we are going to hear it. All of this is very much to be continued. The briefing won't be done until the early fall. And in the interim, everything sort of stayed, but they have vacated that 2-1 decision. So the full court is going to decide whether Judge Boasberg has this ability to pursue the contempt remedy. This is, I think, a very good development in terms of the role of the court. So this is very much put a bookmark in it, and we'll come back to it. But that was big news. And I think for the judiciary and Judge Boasberg, very good news.
Yes. No, I agree. Okay. Woo. Take a deep breath. Let's take a break. We'll come back. We'll talk about the Minnesota indictment and some other things before we have Tess join us. Welcome back. So, as promised, we do want to talk briefly about the Minnesota charges that were announced last week through a multiple count indictment against 15 different protesters with a variety of charges. But the primary charge is a conspiracy. It's titled a conspiracy to impede or injure a federal officer. And what that really means and what the statute prohibits is conspiring to prevent by force or intimidation or threat a person who is a federal official, in this case, we're talking about ICE agents, from discharging their duties. And there's been a lot of discussion about this really being an overreaching indictment that is trying to penalize the exercise of First Amendment rights, because certainly so much of the protest activity in Minnesota during that ICE surge was protected First Amendment. And that includes things like signage and chanting and protesting outside of ICE facilities. It's also protected to follow ICE officers from a safe distance in your car. It's also protected to film public officials doing their jobs in public. That is a First Amendment right. It is perfectly protected to talk with others who are like-minded about your plans to go engage in protest, right? Your plans even to record ICE officers doing their jobs in public, your plans to even call out their license plates when you see ICE officers so that others can be there watching for them. That is all protected. And there is a lot of that in this long 94-page indictment. But what is not protected under the First Amendment is violence or incitement to imminent violence. And frankly, the indictment doesn't really have violence in it. It has some conversations about the potential for violence, but not real violence. But it is also not protected to actually physically or through threats or intimidation to impede or hinder federal agents from doing their jobs. That is something that is a violation of federal law, and that conduct is not protected. So there's a whole lot in here that's protected. But there are some allegations, I think, reading it, of a conspiracy to do things like physically block ICE agents from getting into the Whipple building, which was a building that they were using for detaining people and staging operations and things, and from getting out of that building. These were called soft blockades and hard blockades.
Right. And so there's no question that there are parts of this indictment that has language that if you read it in isolation, you'd say, well, that is really protected First Amendment activity. Also, the way it deals with so called Antifa and whether Antifa is behind this, although this is a 95-page indictment. And I kept on thinking, Mary, where is the supervisor?
Yes.
Because reading this, I went, somebody who wrote this is really, really young.
Yeah. Or inexperienced, I suppose, not necessarily young.
And not only because it just goes on and on and on in a way that indictments don't, but it has an egregious typo in the way that it uses the charging language in 372, the conspiracy that you talked about. It doesn't actually literally track the language. So there was a typo there. And even though there's essentially 90 pages of factual allegations, which is way overkill, what you need to do each time you charge something is you reincorporate all of those facts, and they didn't do that. So the first count has 90 or so pages of facts, but then the rest of it, nobody incorporated all of the rest of it. So all of that was a suggestion to me that this just felt, it's not quite slapdash, but just so inexperienced. And this is a big, important case for the government in the way they did it. But having said that, I completely 100% agree with you that the core allegations, if proved, are not, to my mind, subject to an attack saying that this is protected First Amendment activity. There is no protected First Amendment activity to engage in threats, intimidation, and force with respect to federal officers. And if that can be proved, that's not a First Amendment problem. But as you and I have said, there is a First Amendment problem, which is when you compare what this case is to, let's just say, the January 6th case.
Did they do any threatening or intimidating or physically injuring any law enforcement officers who were dutifully doing their jobs?
So this is one where you say, well, Todd Blanche and the President of the United States have said that that was a grave national injustice. And why is that a First Amendment problem? You have a case of vindictive and selective prosecution because you have, on the one hand, people who have been proved to have done something that is at least as egregious, but I would say clearly for many of those people, far worse than what was alleged here. And those people were not only not eventually prosecuted, they were pardoned, and the government wanted to actually give them money for what they engaged in. And here, for this activity, they're being prosecuted. And so it's viewpoint discrimination in that, and one, it's like, I don't like the message of what they're doing because it's against our policies. But when it's for our policies, which apparently is attacking the Capitol, that is the problem.
That's the heart of selective prosecution, right? You're treating different people differently. And I'd say there is another problem. I think in a way you're being kind to whoever wrote this to say it's sloppy and slapdash. I actually think there's a purpose for the 94 pages, and that is to paint these protesters as really bad, evil people. I mean, the descriptions of them as Antifa, right, is very consistent with the constant attacks by this administration on protesters, particularly protesters against ICE activity. And I think that a lot of why they put all of the detail in here about, they had signal chat groups to coordinate their activity, like there's something nefarious about that. Well, guess what? You're allowed to coordinate your protest activity on Signal, right? You're allowed to train on things like this. So I think part of it is to try to make it sound really nefarious when at the heart of it, there might be a few things, if proved, that would violate the statute, this kind of physical blockading and impeding the officers, but a whole lot of what is in here would not. So we will see whether there are motions filed, and I'm certain that there will be. to dismiss this on selective prosecution grounds and vindictiveness grounds. Much, much more to come.
And maybe that's a great way to quickly address the chief judge in Minnesota has issued a lengthy decision quashing 6 grand jury subpoenas. The lead defendant is Governor Walz. And maybe the best way to summarize what he said is he looks at these subpoenas and he gives the government lots of rope to say, tell me why you are conducting a good faith grand jury investigation, very much like Judge Boasberg in the Federal Reserve Jerome Powell case, where he quashed that subpoena. And ultimately, the judge quashes it, saying that the department is not conducting a criminal investigation, but is instead using the grand jury process for other unlawful purposes. I hope that everyone's sitting down. That is the chief judge, who, by the way, was not appointed by a Democratic president, was appointed by a Republican president. The judge here clerked for Antonin Scalia and says this is unlawful activity that is clearly being done to retaliate and to try and coerce the state to engage in and adopt Donald Trump's policies. And that is the reason this has been brought. He quotes, as we mentioned, Todd Blanche, his threats, also other people, Pam Bondi and the president, in reaching his conclusion, and finds that it's absolutely beyond peradventure that that is the improper purpose that is going on here. And it's not counterbalanced by any justification for a legitimate factual investigation into alleged criminal wrongdoing. So chalk this up to so many of the other rulings, the 6 members of Congress, the Jerome Powell case, the Letitia James, the James Comey cases.
Quotes from Judge Boasberg's decision quashing the Jerome Powell subpoena, too, by saying it's an improper purpose. It was in retaliation. And the chief judge here, I think, goes through it's so easy for anybody to read, to set up that the surge happens, the state of Minnesota and the city of Minneapolis sue in federal court to try to block some of the violations of First Amendment rights and Fourth Amendment rights that were taking place. And then right after that, President Trump posts a message on social media implying that they were violating the law and says the day of reckoning and retribution is coming. Todd Blanche goes out and says they're violating the law. Pam Bondi goes out, writes them a letter saying, you need to do all these things if you want us to leave. And what happens next? These subpoenas.
Exactly. So, Mary, why don't we take a break and then we're going to turn to Tess Bridgman and Iran. What are the legal issues and what does she see as the issues going forward?
That sounds great. Welcome back. As promised, we are very pleased to have Tess Bridgman joining us today. Regular listeners will know her because we bring her in when we have important international law issues to discuss. No one knows them better than Tess from her time in the White House, in the National Security Legal Advisor's Office, as her time in the State Department. And here in particular, she was there, as was I, but not nearly as involved in the Situation Room during the negotiations of the JCPOA during the Obama administration.
And what is the JCPOA? Tess, maybe you could tell us, because we're going to be saying JCPOA and people are going to be like, what?
Yeah, that's a helpful place to start. So the JCPOA is the acronym for the Joint Comprehensive Plan of Action, which also got called the Iran deal a lot. And we can use either of those terms. It's the deal that was reached in the Obama administration to verifiably constrain, roll back Iran's nuclear program, put in place some limits that were permanent, some limits that lasted 10, 15, 20, 25 years, respectively. Basically, the idea was cut off the pathways to a nuclear weapon, ensure incredibly rigorous monitoring and verification, cradle to grave international monitoring and verification of every step of Iran's nuclear process, allow access by international inspectors, et cetera, all of that then in exchange for phased sanctions relief from the United States.
Phased being a key word there, right?
That's right. And the nuclear steps had to happen first.
So, Tess, does it make sense in terms of our discussion today to talk about what we understand the current deal is, what this memorandum of understanding, how you think about it, and then comparing it to what I'll call the Obama-Iran deal? And then what are the flags for you? Like, what are you looking for going forward?
Absolutely, so long as I can throw out one wrinkle in the front end, which is that this is an interim deal, and we in the Obama years also had an interim deal. And it was called the JPOA, the Joint Plan of Action, just to make things incredibly confusing for folks. Why don't we call it Obama's interim deal? And that one was like the MOU we have in front of us right now, an arrangement that aimed to do a little bit of freezing things in place, a little bit of rollbacks, and set the framework for what the negotiations were supposed to accomplish going forward. So, if we want to do an honest comparison, we can't look at the final 159-page JCPOA with 5 annexes and everything that went with it. The honest comparison is actually with the interim deal, and that will still give us all of these benchmarking questions about what a final deal could and should entail now, comparing it to what Obama did reach as a final deal.
So let me make sure I understand. With the Obama deal, there was an interim deal, and then there was ultimately the final deal. And that, when we look backwards, we can see both what was done in the interim basis, then we can see ultimately what was the final conclusion. And so there's this two-step process. And your point is that if we're looking now at what the Trump administration is doing, we don't have that final piece yet. So we can't do the apples to apples on that.
Exactly. So let's see what we have right now. So the MOU. The very first, most basic thing is that this MOU also had to end a war. And in the Obama administration, we had not started a legal war of choice. We hadn't bombed Iran twice during nuclear negotiations. So we are in a fundamentally different world than we were in the 2014-2015 timeframe. So this MOU had to end the war on all fronts, including the Israel-Lebanon war, but it introduces an additional set of spoilers that we didn't have in the same way back then, right? It immediately lifts the U.S. blockade on Iranian ports in exchange for Iran reopening the Strait of Hormuz.
Which was not closed prior to us starting this war.
Correct. It was closed as a result of this war. That not only is one of the other key things that negotiators had to be focused on in this MOU, it's something that's an incredible new source of leverage for Iran, not because we didn't know they could do this. It's one of the reasons the war was deeply unwise, but because now they know it works if they try. And so that's an additional source of leverage on their side.
I should say the new book, Regime Change by Maggie Haberman and Jonathan Swan, has detailed reporting of various people in the administration, including military leaders, political advisors, all saying, do not fall for what Israel is trying to do here, and that the Strait of Hormuz is a huge vulnerability. And so it wasn't that this was not flagged for the president, and their conclusion was that he just goes with his gut, even though over and over again, people were saying don't do it, including maybe most prominently J.D. Vance saying that this was unwise.
Right. So we knew all this going in. Nevertheless, he made this incredibly unwise and illegal decision. And here we are stuck with the consequences of we have to use some of our leverage to get things that shouldn't have even been on the table, which is ending a war, opening the Strait of Hormuz. None of that had to be on the table in our discussions because we didn't make those unwise decisions on the front end.
And the hour being under the Obama administration.
Correct. And so to get to what's going on the nuclear for sanctions front, which is the comparison we want to make, the nuclear bucket of commitments, it's very small in this MOU. It's a lot smaller than the interim deal under Obama. It's less detailed. And here's what we've got. We've got Iran reiterating that it will never produce nuclear weapons. Well, that's not new. That's been its official stance for decades. And in fact, the U.S. intelligence community has assessed that since the early 2000s, about 2003, they haven't even had a nuclear weapons program. So this is consistent with all of that. There's nothing new there. It's important that they restate it, but this is not a new thing the MOU achieved. Second, we get a little bit of what's sometimes known as a freeze for freeze, a common technique, and it's especially useful as a confidence building measure, as an interim step towards a bigger arrangement where you can stop things in place to give yourselves time to negotiate further. It's used in a variety of contexts. And here, what's important about it is that Iran is agreeing to maintain the status of its current nuclear program. And the U.S. is agreeing to more than just a freeze of nuclear-related sanctions. So here's one of the key places where it already goes way beyond Obama's interim deal. The freeze is a freeze on Iran's nuclear program, and on the U.S. side, it's a freeze on any new sanctions. So during the interim Obama deal, it was only nuclear related sanctions. And the US will not deploy any additional forces in the region. That's a big deal. And that's something that wasn't even on the table in the Obama years. We never would have agreed to something like that. But again, we didn't give away our leverage by starting an unwise war and essentially losing it. And then the other key nuclear paragraph is paragraph 8 of this MOU. And it essentially boils down to an agreement that the fate of enriched material and the fate of all other mutually agreed nuclear related issues, including Iran's own nuclear needs, as it puts it, will eventually be addressed in the final agreement. And there's some language indicating that at minimum, what Iran is going to be required to do is make its currently really highly enriched uranium less highly enriched by doing something called downblending it. And they would do that with international inspectors watching. That's all we've got. That is a much smaller and more constrained set of nuclear concessions than was made in Obama's interim deal, which included no new enrichment beyond a 5% cap, no new advanced centrifuges, no new nuclear sites, no new advances at the existing ones, et cetera, et cetera. I could go on, but also a key reduction of the stockpile as an interim step. The uranium was already much less enriched than what Iran has now after Trump withdrew from Obama's deal. So that much less enriched uranium stockpile was cut in half as well under the interim deal. And we're not seeing something like that now, right? We're not seeing in this interim deal Iran saying, we're going to cut in half our currently pretty large stockpile of even more highly enriched uranium. So that's the nuclear side.
Is this fair? I mean, the way that paragraph reads to me is like we're punting all of this to the final agreement, all of the details here. And I think that is so key because the deal under Obama was really all about the nuclear program. That's the entire reason, right, that we were having these negotiations. Whereas here, as you've pointed out, we needed to end a war. We needed to open the Strait of Hormuz. And now Donald Trump has said the reason for that war was to make sure that Iran would never have a nuclear weapon. So it strikes me that the weakest part of this MOU seems to be about the nuclear capability.
The reason we supposedly were going to war.
That is absolutely the case. And look, just really briefly to put on what the other side of the equation is, the sanctions relief. So the exchange, it's saying we're not going to deploy new troops to the region. That's a huge concession. We said no new sanctions, period. And the Obama administration never agreed to anything like that. It was just nuclear-related sanctions. We were still increasing sanctions for things like terrorism and some of the proxy actions, the missile program, et cetera. So this no new sanctions is a big deal. But in addition, we're immediately waiving sanctions on Iran's crude oil and on their fossil fuel industry. The Treasury Department, as we record, has already gone through their internal process and made it public that Iranian crude is on the market. So that's a huge, immediate front-end concession.
Tess, J.D. Vance has been publicly saying, no, we're only making concessions if Iran does X, Y, and Z. But what I'm hearing you say is, at least with respect to this, that's not true, that the sanctions relief is current. And the issue about what's going to happen with the nuclear program, as Mary said, is kind of can kick down the road.
That's right. We seem to have agreed to 4 things in this MOU. The immediate lifting of sanctions on Iran's crude, repatriation of Iran's funds held overseas. And that means that we froze a bunch of Iran's own assets using our web of sanctions. We're going to find ways to let them have access to their own funds that have been frozen abroad. It's unclear to me exactly how much that entails. Could be a pretty large sum. We agreed to later, when we do the nuclear discussions, to a phased ending of all of our sanctions, primary and secondary. That was never on the table in the Obama administration. We kept our entire primary embargo on the books with a couple of minor exceptions, and our secondary sanctions on everything but the nuclear file remained on the books. So we agreed to do that in the later negotiations. And then there's this $300 billion Reconstruction and Economic Development Fund, TBD. We don't know what that is. And so that's another big question mark around this. I might put that more in the we started and lost a war bucket than in the nuclear bucket.
Because there's a lot of things destroyed in Iran because of our bombing, right?
That's right. So when you look at the nuclear for sanctions compromises, it's complicated because you're not going to say in a deal like this exactly which thing corresponds to which concession on the other side. But I think that's more in the ending the war side of things. So the question mark's what we still don't know about what a final deal might achieve. Will the international inspectors have access to the entire nuclear supply chain like we did in the Obama deal? We don't know. Will there be 24/7 monitoring? We don't know. Will the international inspectors have access to any suspicious locations if they need it in a short enough time frame that those locations couldn't be cleaned of any nuclear materials? We don't know. Will there be a dedicated channel for Iran to buy or procure materials or technology that it could use in its nuclear program, enforced in a binding Security Council resolution that all countries have to abide by? We don't know. Will they agree not to enrich uranium over the low 3.67% cap that we had in the Obama deal? We don't know. Will there be at least 1 year breakout timeline for additional restrictions on weaponization? We don't know. What will the duration of the commitments be? Will some of them be permanent? Will some be at least 25 years like we had in the Obama deal? We don't know. All we know, the framework that was put around these future negotiations is much more slim. And those are the kinds of benchmarks in the Obama deal that, quite frankly, I just don't think are realistic anymore because the United States has less leverage. It's playing in a more complicated environment where it has to deal with the military dimensions of this can of worms that is opened. It has to deal with the economic consequences of Iran having leverage over the Strait of Hormuz, which didn't exist anymore. And we don't have a multilateral coalition on our side.
That was like a big issue for me. Could you speak about with the Obama deal, what countries were on board, were dealing with this, and how would you compare that to what is happening now? I think the three of us are just from our prior jobs, we're so focused on America and the importance of international cooperation and a one world approach to this.
Yeah. The United States clearly took a leadership role in the negotiations that eventually achieved the comprehensive deal that we ended up with and the interim deal before that. But as part of a multilateral coalition in lockstep with partners, and not just during the negotiations, but during the years, right? Going back pre Obama, during the years that preceded those negotiations, where we ratcheted up sanctions in response to Iran ratcheting up its nuclear program. And the understanding always was, and the only reason our sanctions regime was effective was that there would be an off ramp if Iran agreed to roll back its nuclear program and agreed to what the international community wanted, which was ensuring that international inspectors could know that the program was for exclusively peaceful purposes and that that was going to be airtight. So when we stopped other countries from buying Iran's oil, those other countries only went along with that grudgingly because there was a serious multilateral diplomatic effort underfoot to actually deal responsibly with Iran's nuclear program. And we weren't launching unnecessary illegal wars to try to do it. We were engaged in good faith in this negotiation process. So who ends up being part of the actual negotiations? It's the United States, France, Germany, China, Russia, the UK, and then Iran on the other side. And what that is essentially is it's the permanent members of the Security Council, plus Germany, plus the European Union in its own right, and Iran on the other side. And so when you think about the heft of that coalition, the seriousness of it, it is what enabled us to really get the concessions that we needed out of Iran, but also to get the whole rest of the world on board. So when I mentioned, for example, that our final deal had these limits on how Iran could buy materials that it might be able to use for its nuclear program, well, why would Korea, India, why would everyone go along with that? Because this was the permanent members of the Security Council, and it was later endorsed by a binding Security Council resolution that put those limits in place. So the entire international community was on board in a sense, but we had these key partners in our European allies, plus Russia and China at the table. And here under the Trump administration, what we have is no allies, literally.
Could you just say that once more that Russia and China were at the table under the Obama deal? That just seems like a major, major difference.
It is a major difference, and it both gave the negotiations themselves a level of complexity. The United States and our European partners and Russia and China had to get on board with what our side of the deal would entail. And Iran, of course, is sitting on the other side of the table. It also, in some ways, though, gave us some more flexibility, but also a key set of points around trust. The United States and Iran have not had trust for decades. This is not new under the Trump administration, even though it has reached new lows. And so having all of these other players at the table made it a situation where it didn't necessarily increase Iran's trust in the United States, but it gave us a solid baseline for all parties to understand that these discussions were serious, that we were not going to be trying to pull the rug out from under each other halfway through and start dropping bombs, right? That was out of the question. It should have been out of the question for the Trump administration as well, but they've now done it twice. And so the whole idea of the US and Iran coming together, sitting down at the table, would you trust someone to sit across the table with you to resolve a dispute when the 2 times prior that you'd tried to do that, they just stood up and punched you in the face? Or would you say that's not a table I feel safe sitting at?
And we've heard what Donald Trump said, even in announcing this interim agreement, that sounds like, well, if they don't do it, we'll just restart bombing. So trust is a huge issue, like you say, Tess. But before we wrap today, there's one sort of part of our government that has not been mentioned, and that's Congress. So what's Congress's role here?
Yeah, that's a great question. And there's what Congress's role could and should be. And there's what Congress has done to tie itself and the rest of the government in knots with what's called the Iran Nuclear Agreement Review Act. And we'll just call that Congress's Iran deal oversight statute. So what Congress did while Obama was negotiating was try to give themselves an opportunity to either kill the deal or at least create themselves enough space to do a whole bunch of political grandstanding and say how bad it is and how much they hate it and give themselves an opportunity to vote against it. Voting against diplomacy was in vogue back then. We warned folks that the alternative, of course, that was actually the backstop of war was not a good one and not a path folks wanted to go down. We've now seen how that plays out, unfortunately, but that was what the politics were in 2015. So they passed this statute. And it essentially had a couple of different components. It said any deal relating to Iran's nuclear program and that commits the United States to take any action has to come to Congress for review. It has to be transmitted within 5 days with all of these verification assessments and certifications. And then Congress gets a 30-day window to review it, and they can essentially vote it up or down. That's an oversimplification, but if they vote it down, essentially the waivers that the president needs to give sanctions relief disappear. And without sanctions relief, no deal. And so they gave themselves on the back end as well a whole bunch of oversight tools that are incredibly stringent that essentially say if there's any non-compliance on the Iranian side, they can snap sanctions back into place then as well. And the executive branch has to very closely report that to Congress within days, not months. And if it's unresolved, then they can snap back U.S. sanctions. I should note that the actual underlying deal allowed the executive branch to snap back sanctions whenever it needed to. So this was Congress giving itself additional leverage to do that beyond what the executive branch already had. So this statute was very squarely intended to hamstring Obama. It was intended to throw obstacles up to Obama's multilateral achievement of stopping Iran's nuclear program and rolling it back in significant respects. They wrote it so broadly that it applies to this MOU and any other arrangement the United States might ever enter into that relates to Iran's nuclear program and commits the United States to take any action. So what that means is that the Trump administration is already supposed to have submitted, because we're more than 5 days out, these verification assessments and certifications to Congress. And Congress should now be in its 30-day review period where it can vote up or down this MOU. That is not a good thing, right? Congress should not be voting up or down a peace deal. And that's the complication we now have. Because they wrote this so broadly, that's why it's not an effective oversight tool of the nuclear file. If they want to do actual nuclear-related oversight, passing this statute that applies to any deal or arrangement, including if it's a ceasefire, is not the right way to do it. Because if they want to vote down the nuclear components, they also have to vote down the ceasefire, and they should not do that. That would be a tremendous mistake. It would be a huge own goal. We cannot continue this war. We have to end it.
Are you saying that Congress should not do it as a matter of policy? Or are you saying that it's wrong as a matter of its power, that it shouldn't actually have had the statute, or both?
I think there's a couple different components here. One is clearly as a matter of policy, while this MOU, in the ways that we just talked about, this interim deal that the Trump administration has, is not great for the United States in a lot of ways. It does reflect the reality in some important ways of the moment we find ourselves in, of essentially having gone to war illegally and basically lost that war. Best characterization is kind of a bad stalemate, right? So it does kind of reflect that reality. But more important, going back to war is not a viable alternative. So there's no scenario in which diplomacy shouldn't be given every serious effort. And that means continuing along the path that this interim deal started and trying in good faith to get those negotiations to bear out, bringing in our partners from the European Union, France and China, bringing to the table whoever needs to be there to give peace an opportunity to succeed. Congress voting up or down this interim deal is not a helpful part of that negotiation process. And so that's kind of point number one. Point number two is they intended the statute to apply in circumstances where the United States hasn't entered into anything binding. And let's be clear that Congress has a key role to play when it comes to both the treaty process or other binding executive branch agreements. There are other statutes on the books that govern those. There's a specific statute that governs nuclear cooperation agreements. This is not one. The United States is not agreeing to cooperate with Iran on its nuclear commitments, nor did it ever do so under Obama. So this is for a non-binding set of political commitments that's aiming to get the rest of the world to go along with us to curtail, roll back, and inspect and verify Iran's nuclear program. This is not a statute that is helpful for Congress being involved in doing that. Now, they don't have to vote the thing down. They don't have to vote at all. So now that this is on the books, I think there's two things they can do. They can repeal the thing, right? They can amend it. The key thing we haven't discussed is that the statute forbids providing relief from statutory sanctions during this review period. So it's already being violated.
Exactly.
Right, it's violated.
By the fact that the crude oil is already flowing. So they could have amended it to take that one provision out so that sanctions relief can be effective immediately. Because again, that's negotiating leverage. Would I like to have seen sanctions relief follow nuclear commitments? Of course, but that's not the deal the Trump administration got, right? So what we have now is a rule of law problem where the statute is not being followed. A war problem is arguably an even worse problem. But that's the situation we have found ourselves in. So Congress should be repealing or at least amending this statute to take out that provision. But now that we are where we are, the other thing they can do is just not act further. They don't have to vote on this thing one way or the other. My guess is that that's where we will end up.
I think so too.
Seems like what Congress would do. So Tess, we could talk to you all day long because this is so fascinating. I cannot thank you enough.
And so complicated. And I think what you've said here is so important. I feel like a lot of what the media is doing now is pitting this deal against the Obama deal. And of course, we did break that down. But your point at the end, we are where we are. The war needs to end, right? The strait needs to be opened. We have to play with the cards where they are on the table right now. And it's better to have a peace deal than to not have a peace deal. Thank you for helping to elucidate that for all of us.
Thank you both for talking about this today.
So, Mary, tell us about the Las Cruces case.
Very briefly, because we can come back to this when the government files its response. The government has decided, in continuing to build its border wall, that it wanted to take property owned by the Catholic Diocese of Las Cruces, New Mexico. This is property, a mountain called Mount Cristo Rey. It is a holy site right at the border of New Mexico and Mexico, really also almost to the border of Texas as well, that little corner there. It is an over 4,000-foot mountain. At the top of that mountain is a 29-foot limestone statue of Jesus Christ. And it is an important pilgrimage site that's been a pilgrimage site since the 1930s for Catholics and other people of faith in the borderland area to make pilgrimages up a trail to this statue, which looks out over New Mexico and is a place for contemplation and reflection, etc. The Trump administration wants to take a strip of land at the foot of that mountain to build its wall. And so they have, under the right to eminent domain, filed a declaration of taking. And ICAP, my organization, is representing, along with local council, the Catholic diocese, and saying, no, that a wall there is completely against Catholic teaching about the universality of human beings, welcoming to migrants for basic needs, food, shelter, etc. We understand your need for secure border. There are other alternatives. The Catholic diocese says we have to oppose any taking to build a wall that is so fundamentally at odds with Catholic teachings. That is where things stand. We will put in the show notes a link to a New York Times article that tells very poignantly how this holy site has been used by the faithful. And of course, there will be much more to come on that. Suffice to say, the Trump administration thinks that eminent domain means First Amendment religious rights, the religious freedom statutes passed by Congress, that those don't mean anything when it wants to take property. And that's what we're fighting about.
More on that, and there's so many to be continued. Our thanks again to the wonderful, wonderful Tess Bridgman. Thanks everybody for listening. Remember, you can subscribe to MS Now Premium on Apple Podcasts to get this show and other MS Now originals ad-free. And you'll also get subscriber-only bonus content. A reminder, we are available on YouTube, so you can head to ms.now/mainjustice to listen.
This podcast is produced by Vicky Vergolina. Nicholas Vinuela Yodar is our associate producer, and Cassidy Corey is our intern. The audio engineers for this episode are Bob Mallory and Hazik bin Ahmad Fared. Katie Lau is the senior manager of audio production, and Aisha Turner is the executive producer for MS Now Audio.
Search for Main Justice wherever you get your podcasts and follow the series.